My name is Mitchell Rogers, and I represent Mr. Kenneth Grant, and I'm joined by co-counsel Bot Sheva Tabachman.
All right.
Your Honor, Katrina Parker, Dallas County Public Defender's Office. We represent Ms. Johnson.
We're set here on a prior reset on the motion for enforcement. So we're proceeding today with the First Amendment amended motion for enforcement for possession and access and the geographic restriction. Is that correct?
Correct.
Yes, Judge.
All right.
So very briefly, we're here on petitioner's motion for enforcement in regard to violation for geographical restriction and access. If the court recalls, Ms. Johnson previously testified before this court that she had moved to Mississippi, and that additionally she has interfered with Mr. Grant's possession and access. And Mr. Grant is requesting at this time the court find her in contempt for such violations, and he is asking for additional makeup time and for attorney's fees.
Thank you, counsel. Attorney Parker.
Your Honor, I don't know if mom was represented at that time, respondent. I would ask that that testimony be stricken if she was not, without advice of counsel about testifying.
At the April enforcement,
Yes, Judge.
she was still represented by counsel. Her counsel didn't withdraw until three days. Well, filed the motion to withdraw until 3 days later.
Thank you, Judge.
You're welcome. You may proceed with your opening, counsel.
I'm finished. Apologies.
No, Attorney
Close my
Parker.
opening.
I don't have one, Judge.
Okay, all right. Attorney Rogers, you may call your first witness.
Okay, Judge. I will call Kenneth Grant.
All right. You may proceed.
Alrighty. Please state your full name.
Kenneth Maurice Grant,
Where do you reside?
1430 Snowberry Drive, Allen, Texas, 75013.
And this is the court of continuing jurisdiction?
Yes,
And you are the father of Carter Michael Grant, who is the child subject to the suit?
yes,
How old is Carter?
5 years old.
And was there an order entered naming you a joint managing conservator of Carter?
Yes,
And this order granted you a standard possession schedule?
yes,
And this was entered on or about June 22nd, 2022?
yes,
Do you see Ms. Johnson on Zoom here today?
yes.
Can you identify an article of clothing she's wearing?
I'm gonna find her on here. Something black. I only can see half of her face, like a black sweater.
Okay. Judge, please let the record reflect that the witness has identified the respondent, Tabitha Johnson.
Noted.
Under the current order, does Tabitha Johnson have the right to designate the primary residence of the child?
Yes,
And this is subject to a geographical area?
yes,
And that area is Dallas County or any contiguous counties?
yes,
Has this order ever been modified since it was signed by this court?
no,
Judge, I would ask the court to take judicial notice of the child support review order signed by this court on or about June 22nd, 2022, and which is Father's Exhibit 2, which has been pre-admitted, and specifically the paragraphs entitled Possession and Access found on pages 20 through 27 of Father's Exhibit 2, as well as the paragraph entitled Conservator starting on page 2 through 4 of Father's Exhibit 2.
Okay, the court takes judicial notice of the order as well as all contents of the court's file.
Okay. Mr. Johnson, did Ms. Johnson move to Mississippi?
yes.
And how do you know that she moved to Mississippi?
She stated it through text messages. Also, a police officer told me when I went to her home.
Objection, objection, hearsay, Your Honor.
Sustained. Mr. Grant, you can't tell me what someone outside of this hearing told you. Sustained.
Okay. Well, she told me up through text.
Moving,
Hold on,
moving on.
Mr.
Sorry.
Grant. You can't say what someone else told you that's not in this hearing. So you can tell me things that Ms. Johnson told you.
That's what I said. I
Okay.
said she told me through text message.
Oh, okay. I thought you were saying he as in the
Well,
police.
that was a second, but the first part was she told me through text message.
Okay, thank you. My apologies.
No problem.
And Mr. Johnson,
Mr.
she
Grant.
moved, yes, sorry. Mr. Grant, she moved after the order was entered, correct?
Yes.
Okay. And, Judge, permission to share my screen?
Yes.
Okay. Okay. 1 second, here we go. Okay. Alrighty. Can y'all see my screen?
Not
No.
yet.
Okay. 1 second. Alrighty. How about now?
Yes.
Okay.
Yeah.
Okay. Mr. Johnson, is this Father's Exhibit 3, the text message which references the conversation between you and Miss Johnson?
Yes.
Okay, and this is the message highlighted where she had stated it that you were referencing?
That's one of them. Yes.
Okay. All right. Now, Mr. Johnson, please take a look. This is Father's Exhibit 6, which is another message where she had stated referencing Mississippi, correct?
Yes.
Okay. And then the conversation with the officer that you previously mentioned this is it referenced in Father's Exhibit 5, correct?
Yes.
Okay. And then you recall that, and then,
Your Honor, we
so,
object to the hearsay within the exhibit.
Hold on 1 second. It's already admitted. So are you asking the court to pay attention to only that which is not hearsay and give it its
Yes, Judge.
appropriate weight?
Yes, Judge.
Okay. Counsel, you may proceed, Attorney Rogers.
okay. And then, Mr. Grant, on or about Friday, April 2nd, did Miss Johnson surrender the child to you?
No.
Did she later surrender the child to you at her residence at 6 p.m. later that day?
No.
Okay. Um, have you made police reports?
Yes.
Okay. And then this is Father's Exhibit 6. Is this a police report that you'd made after you had called the police?
Yes.
Okay. And this was a reference to a day that Miss Johnson had failed to surrender the child?
Yes.
Okay. And then if you look at Father's Exhibit 5, this is another police report you had filed, correct?
Yes.
And this is in reference to November 23rd, 2025.
Yes.
Okay. And this is when another time Miss Johnson failed to surrender the child to you.
Yes.
Okay. So on both of those dates, August 2nd and November 23rd, Miss Johnson failed to surrender the child, correct?
Correct.
And she failed to do that at the time school was dismissed at her residence, correct?
Correct.
And the child was not surrendered to you later that day at 6 p.m.
Correct.
Okay. Do you believe that Miss Johnson will violate future orders of this court as it applies to your rights to visit Carter?
Yes.
Was it necessary for you to hire an attorney to enforce your right to visit with Carter?
Yes.
Did you hire me as your attorney and agree to pay me a reasonable fee for my services in connection with this contempt action?
Yes.
Are you satisfied with your representation?
Yes.
Okay. Mr. Grant, I'm going to have you look at what has been marked as Father's Exhibit 1. This is your summary of requested relief, correct?
Yes.
And you're asking that the respondent be held in contempt for each violation.
Yes.
And you're asking for ordering additional makeup periods of possession to compensate for the periods that you were denied by the respondent, correct?
Yes.
And you're also asking that the court pay a reasonable amount of attorney's fees.
Yes.
Okay. And then you're also asking the court order her to pay a bond, correct?
Yes.
Okay. No further questions for this witness, Judge.
All right. Attorney Parker?
Thank you, Judge. Mr. Grant, in your petition, you allege 8 violations, is that correct?
I'm not sure on the
Okay.
total amount.
Okay. Well, let's talk about, well, you want her to pay per violation. Are you seeking that for 8 violations or just the 2 or 3 that you mentioned?
Whatever the judge, I mean, the lawyer just stated, I'm not sure the amount of violations.
Okay. Let's talk about the August 2nd one you mentioned.
Okay.
What time did you arrive to her home?
I believe it was 6 o'clock.
Do you have proof of that you were there at 6?
Yes.
What proof is that?
The police report.
Okay. What time did you contact the police? Soon
Oh,
after arrival?
I believe so.
Okay. The police report starts at after 8 p.m., sir.
Okay.
Okay. Did you arrive to the home somewhere a little bit before that?
I arrived around 6 p.m.
Why did you wait so late to call?
I don't recall waiting till 8 o'clock. I'm not sure exactly what time, and I don't, if it's saying
Honor,
8
I'm going to
o'clock,
object this to relevance.
yeah.
Your Honor, it's extremely
Overruled.
okay. Sir, yes. So you arrived at 6 and you didn't call the police until after 8 p.m.?
I'm not sure what time I exactly called, but I arrived around 6 and I did call the police once I
Okay.
arrived. I went to the house initially first to try to see if she was there. I knocked on
Objection, non-responsive, Your Honor.
Sustained. Mr. Grant, wait for the next question.
Okay.
Okay, sir, you're telling the court you arrived at 6 or after 6, but the police report shows you didn't call in until after 8. So do you think perhaps you arrived around 8 or 7:45 or something like that?
Well, perhaps I may have called a little bit later after 6.
Okay, do you have proof that you were at the home at 6? Do you have a picture of you at the address with a timestamp?
Not that I'm aware of.
Okay. All right. And then the second one you mentioned was November 21st, 2025. Is that correct? That you testified to?
Yes.
And that I'm sorry.
I think it was 23rd.
Okay, November 23rd. All right. In your pleadings, you note that on November 21st, she failed to, let's see. You say November 21st, she failed to surrender the child to you at the beginning of the time the school was dismissed for Thanksgiving residence at your residence. That's what your pleadings say. So you're alleging November 21st was the day that possession started, but you're giving proof on November 23rd. So you showed up on November 23rd, correct?
I'm not sure about dates. I'm not sure about the dates. It's like you're trying to twist me up with dates. I'm not sure about the dates. Whatever on there are reports, like police reports, or whatever date that's on there should be the date that it happened.
Okay. So your police report shows November 23rd. That's when you showed up to exercise your possession, correct?
Yes.
Okay. Are you aware that your possession, according to your pleadings, you allege November 21st was a date you should have shown up?
Didn't you say it's supposed to be at my location on the 21st?
That's what you wrote.
Okay, it wasn't on it. She didn't come on the 21st.
Okay. Sir, have you reviewed your possession order?
Yes,
Were you familiar with it before these attempts of exercising possession?
yes.
Okay. And November the 23rd, that was the week before Thanksgiving, correct?
I'm not sure.
Okay.
Thanksgiving is on the 25th, correct?
Of that year of 25? That was the week leading to it. Your order, is it correct that your order gives you possession on the day the child's school is dismissed for Thanksgiving break?
I'm not sure
Okay,
about the dates. I'm
All
just
right.
not sure about the dates.
okay. And also, where was she living at that time?
In Mississippi,
Oh, okay. And you went to where to pick up the child?
um, I'm not sure every time. Her home.
Her home? Okay,
Let me look at my stuff.
that's fine, sir.
Okay.
Okay, did on April 18th, you allege that as a date that she failed to surrender the child. Did you show up on April 18th?
No, because I found out she was already moved to Mississippi. And I don't think I showed up on the 23rd either. If I'm thinking correctly, she had already. I found out that she had already moved to Mississippi at the time.
Well, the police report says that they made contact with you on 11/23/25. This is from Terrell Police.
Okay, so let me look at my exhibits.
Okay,
I'm getting confused. I'm getting confused on all these dates.
all right. So April 18th, you did not show up. This is your testimony.
Correct.
Okay, but you have that listed as a violation.
Yes, because
Okay,
I didn't receive the child.
because but you didn't show
I
up, sir,
called.
correct? You called?
I couldn't show up in Mississippi.
April 18th, she's not in Mississippi.
Okay, April 18th, 25. Correct. You're asking about?
Uh-huh.
Okay. So yes, I did show up.
You have proof of that, sir?
Yes, the police
Well-
report.
Is there a police report for April?
It should be.
I don't think there's a police report for April 25.
Hmm.
I don't believe you submitted one for that, sir. And then further on that date, Miss Johnson was in Terrell, and are you aware there was no school on Fridays when he was in Terrell? That the Terrell School District didn't have school on Fridays?
No, I don't.
Okay, what
It
is
wasn't
it?
even-
Your
wasn't
Honor, I'm gonna
even in
object to
school.
relevance.
It wasn't
Your
even
Honor, it's
in school.
extremely relevant.
It's overruled.
Okay, sir. Your order tells you that I understand the child wasn't in school. Your order says if the child is not in school, you go by the calendar of the school district. So would it surprise you to know that April 18th, 25 on Friday, that was a non-school date. So therefore your order tells you to pick up on Thursday, the 17th.
I'm gonna object to these facts not in evidence.
Your Honor, it's the order.
Overruled.
Okay, thank you, Judge. Would that surprise you, sir?
Yes, that would surprise me because I've never picked up on a Thursday because of a school date. I've never seen that in my order or understood that to be fact.
Okay. And then let's go to, so we have dealt with I'm sorry, the 23rd, you said on the 21st when you showed up on the 23rd, correct?
Yes,
Okay. And you also allege that she did not deliver the child to you, correct?
correct,
Okay, and then for violation number 4, December 28th, you allege she failed to surrender the child at your residence, correct?
correct,
And on January 16th, 2026, you allege that she failed to surrender the child at your residence, correct?
correct.
January 22nd, 2026, you allege that she failed to surrender the child to you at your residence, correct?
I'm assuming all these dates are correct because I didn't have the child none of that time, so I would say
Okay.
yes.
And then on January 30th, 2026, you allege that she failed to deliver the child to you at your residence. Is that correct?
Yes,
Okay. Sir, do you realize that in your order, there's nowhere in your order, despite the distances that you guys may live, that Miss Johnson is ordered to surrender the child at your residence. Do you understand that?
no,
Okay. So you're alleging she failed to, in counts 3 through 7, you're alleging she failed to surrender the child to you at your residence, and that is not ordered by the court anywhere. Are you aware of that?
I'm aware that she's ordered to stay in geographic restrictions and she had moved to
Objection
Mississippi.
non-responsive, Your Honor.
Sustain.
Sir, I'm referring to counts 3 through 7, where you're saying she did not surrender the child to you
I said she didn't surrender the child at
at
all.
your residence,
I
is what
didn't
you
say
said.
at our residence. I said she did not
That's what
surrender
it says
the
in
child.
your pleading, sir.
Okay, that's what it says.
Okay. And then regarding the residency restriction, how often did you exercise your visitation?
As much as I possibly could.
What does that mean, sir?
Every time I was supposed to, I tried to attempt to get my child.
You try, so since this order was put in 22, I believe your counsel said?
Yes.
So you've made every first, third, and fifth Friday?
No,
Or
I
every
have
first,
not.
third, and fifth? You have not?
I have not.
Okay, in 22, did you make all of them?
Yes.
You made all of them in 2022?
Yes.
Okay, in 2023, did you?
So to be exact, I can't say if I have not missed a day or not. I don't want to say because I don't remember did I ever miss a day. I don't know, but I've attempted to get my child every time that I was supposed to get them,
Okay, so
and a lot of times I was.
Objection non-responsive, Your Honor.
Mhm.
Sustain. Mr. Grant.
Yes.
Any explanation that you would want to give, your attorney will clean it up for you on redirect.
Okay.
Okay.
Okay, sir. So what I'm asking you is so you're saying you attempted to. So if you only made half your visits in a year, you're alleging that's because mom denied them?
No.
Okay. Did you make all your Thursday visits?
No.
Did you have the child for 30 days in the summer, every summer that we've been previous till now?
Yes.
Counsel, you have 2 minutes.
I pass the witness, Your Honor.
Right, Attorney Rogers?
Just a few questions. Mr. Grant, going back to November of 2025, was it in that police report that previously mentioned the conversation with the officer? Is that when you discovered that Michelle Johnson had moved?
Yes.
So prior to that, there were 2 text messages where Miss Johnson had mentioned her intent to move, correct?
Correct.
But between that time that she had texted you and until November, you did not know for sure.
Correct.
Okay. All right. And then referring to referring to the uh referring to the police report for August 2nd, okay, you attempted to go to the house you attempted to exercise, correct?
Correct.
Okay. And then you had you you attempted to go to the house around 6?
Yes,
Okay. And so around that time, were you unsure of
You're on
how to
objection leading.
Sustained, don't
I'll
leave,
I'll
Council.
rephrase. And Mr. Grant, you called the police that day,
yes,
correct?
yes.
Okay. And that was because of the failure to surrender, correct?
Correct.
Okay, thank you. No further questions, Judge.
Okay. Do you have any other witnesses, counsel? Attorney Rogers?
Yes, I would call myself to testify, Judge.
Okay, you may proceed.
Okay. Uh, my name is Mitchell Rogers, and I'm a licensed attorney to practice in the state of Texas since 2025, and the entirety of my practice has focused on family law. Ms. Tobachman, who's board certified by the Texas Board of Legal Specialization in Family Law, has been licensed since 2019 and is here with me today. I practice primarily in Dallas County, and I am familiar with the rates charged by similarly situated attorneys in Dallas. Mr. Grant signed a contract on or about April 16th, 2026 with my firm for me to represent him in the prosecution of Tabitha Michelle Johnson for contempt for failure to comply with this court's visitation order and geographical restriction. I charge an hourly rate of $225 per hour for this type of matter. My paralegal charges $180 an hour, which is a fair and reasonable fee in this county for services which I have performed in this case. Given the nature of the issues and my experience in dealing with lawsuits of this kind, Ms. Tabachman, who is board certified by the Texas Board of Legal Specialization of Family Law, has been licensed since 2019, is here with me today, charges a rate of $480 an hour. To date, not including this hearing or the time spent today in this hearing, I have expended 22 hours on this case, including preparation of the initial paperwork, the investigation, and the courthouse filing of this case, and preparation for exhibits for for the exhibit conference and this hearing today, including multiple correspondences in contacts with my client, and a final meeting to prepare my client for testimony here today, and the preparation for the final order and committed documents. I have further expended $258.39 in filing and service fees for personal service upon Tabitha Michelle Johnson. I finally anticipate spending 30 minutes today on this hearing for a total of 22 and a half hours at $225 an hour, which equals $5,000 plus the $258.39 in fees for a grand total of $5,258.39 in attorney's fees and costs. I believe these fees are fair and reasonable based upon the following factors, such as the time and labor required, the novelty and difficulty of the question involved, the skill required to perform the legal services properly, the fees customarily charged in the locality of similar legal services, the nature and length of the professional relationship with my client, and my experience, reputation, and ability. I pass myself as a witness, Judge.
Thank you, counsel. Attorney Parker, any cross?
Your Honor, just one question. There's another action going on. There was a TRO filed and other things of that nature besides this matter, correct?
Yes.
Okay. No further questions, Your Honor.
All right. Attorney Rogers, do you rest?
Just a brief closing, Judge.
Well, do
Oh,
you
sorry.
rest for your case in chief?
Yes, Judge.
Okay, Attorney Parker, you may call your first witness.
Your Honor, is respondent closing? I mean, is petitioner closing?
Well, he just rest.
Okay.
So now it's your case in chief.
Your Honor, I would like to call Mr. Grant.
All right. And time check, Attorney Rogers, you have 4 minutes and 6 seconds. Attorney Parker, you have 1 minute and 50 seconds.
Thank you, Judge.
You're welcome.
Mr. Grant, are you asking that Ms. Johnson be committed and placed on a community supervision, like a probation?
Yes.
Okay. No further questions of him, Judge.
All right, you may call your next witness.
Your Honor, I'll call Ms. Johnson.
All right, you may proceed.
Actually, Your Honor, I don't want to call her.
Okay,
Finish. Rest, Your Honor.
all right,
Subject to some court requests and closing.
all right. Attorney Rogers, you may proceed with your closing.
You judge. Your Honor, I believe the testimony here has reflected that Ms. Johnson did move to Mississippi, and that she additionally also testified to this court that she had done so. And further, Judge, I would like to ask that my client receive makeup time in order to compensate for the time that he's lost with his child. In addition, Judge, the cost for prosecuting this matter in order to enforce his rights to his child, I would say is necessary and reasonable attorney's fees. And I would also ask that she be found in contempt for her violation, especially in regard to the geographical restriction. At this time, Judge, I rest.
Thank you, counsel. Attorney Parker?
Your Honor, we would ask for judgment for the court that violations 3 through 5 do not support contempt. They're alleging that the child was not presented to dad. That's not in the order. Also for violations 1 and 2, dad was not there, does not have evidence of the proper time being there, has not shown any evidence that he showed up at the date, time, and place that was ordered to be done so. Regarding the residency restriction, mom has testified prior to my counsel, according to everyone, that she did move. Mom is amenable to makeup time to the second weekend of every month for the school year, or whatever duration the court would order in that regard. Your Honor, regarding attorney's fees, I think the fee is excessive. There are other actions that are going on in this. The parties have appeared before Judge Lee. That's not commonplace, except for the exhibit conference, in a contempt action. So I think the hours are excessive for a contempt action of this nature. And we ask, as far as Judge, if the others are stricken and the 500 they're asking per violation, if the court is so inclined to do a fine, that would only be for violation 8.
Does that conclude your request and or closing, counsel?
Yes, Judge.
Thank you. So the court is going to grant judgment as requested on violations 1, 2, 3, 4, 5. The court is also going to grant judgment on violations 6 and 7 because the court did not hear any testimony specifically about those dates. The court does find that the respondent is in violation of, the court does find that the respondent violated the court order by moving outside of the geographic restriction. So she will be held in contempt on violation number 8. I believe mom said that she's amenable to makeup time the second weekend of every month for the school year.
Yes, Judge.
Let's see.
The second Friday, yes.
Second Friday. The court is going to grant that request for makeup time for dad, and mom is going to have to do all the driving. So because mom violated the geographic restriction, mom has to come to Texas to bring the child. Sir, you said you're in Collin County, right?
Yes.
Ms. Johnson, how far is, if you know right off, how far is your home from Collin County?
41 miles.
Your Honor, she's moved back.
Yeah, we've been back.
Okay, so, all right. That
And
makes
Judge,
easier.
just so you know, Judge Lee had them exchanging at the Richardson Police Department due to issues. So
When you say issues, what kind of issues? I really don't like the police department being an exchange location because I don't want a child to think that either of their parents are in trouble or that they did anything wrong. So unless some physical violence occurred or
was.
some,
Yes, February 14th, 2025. He
okay.
did get physical with me.
No violence has occurred, Your Honor.
Okay, hold on. When I say, let me be more clear, unless there is some sort of protective order or something that is limiting you all's interaction. I really don't like making a police station an exchange location. I think a public place would be fine because there are cameras, there are people around. So,
I just don't want to have to go to his door.
well,
not-
I don't think you all need to exchange at the residence. Now, if you all, I can't on my own change the court order from wherever you all are exchanging, because it says in your court order that the exchanges are supposed to occur at your residence. If you all agree to somewhere neutral as a public place, then I think that that will work.
Judge, if I may,
Yes.
we could suggest doing it at a QT, at a Quick Trip.
Okay. Do you have the location of a Quick Trip that's between their two homes?
I can find out momentarily.
All right.
Judge, I'm sorry if I may ask them, is there, since y'all know your routes, they've been doing something, is there somewhere near the police station where you've been going that's public? You've seen a McDonald's or a restaurant?
Yes,
gas station?
there's a QT on Beltline and 75 that's near the police station where we meet.
Okay.
How old is Carter now? What, 6?
5, 6 in September.
Does he like McDonald's?
Yes.
Could we not find a McDonald's Playplace? There's nothing fun in QT. I'm just thinking like a 5-year-old. I don't want to exchange at QT. The only thing I'm going to be able to do is go in there and ask for a piece of candy. I at least want to eat and play. You know what I mean? Like, could we find a McDonald's Playplace?
Yes.
Um,
And make sure you Google Playplace. My daughter had to, school me on that one. If you just say McDonald's, not all of them have play places. I didn't know that until literally a couple of weeks ago.
Your Honor, I believe there is a McDonald's Playplace found off of Campbell Road in Richardson. That is by 75 and on Campbell Road.
All right. Would you provide me the address?
Yes, Your Honor. That address is 170 West Campbell Road, Richardson, Texas, 75080.
All right. Let me repeat that. 170 West Campbell Road, Richardson, Texas, 75080.
That's correct, Judge.
All right. Okay. Both parties agree to that?
Yes, Your Honor.
Your Honor, I think my client is asking for 7 o'clock instead of the 6 o'clocks. Is that
Well-
correct, Ms. Johnson?
Yes, that's correct. Due to my work schedule. It makes it impossible pretty much to be able to get off work and get Carter and then get Carter to Richardson. We're 35 minutes without any traffic away from Richardson.
Is there someone, because your order allows an exchange to occur with a competent adult, is there someone else that you can designate to get there at 6?
There's honestly not. That was the reason I was needing to move, because all of my family has moved to Mississippi. So either my help that I do have, they're working, themselves, or they, it's just not possible. In the summer, my sister was able to do it because she does not work on Fridays in the summer, but she works for the school district. So when the school's in, she definitely cannot.
Okay.
And I don't want any violations moving forward, for sure.
And I think, Judge, we're looking at the order Dad still have made the elections for after school.
Mhm.
Carter will be in school. He had a September birthday, so he'll be in this year. So Dad can do his after school pickup. So it shouldn't be that many times that 7 is in play, but I'm just pointing that out.
So with that, Mr. Grant, will you agree on the times that, or on the days that you have to pick Carter up outside of being at school? Will you agree to the 7 o'clock pickup?
Up until now, there's never been a problem with 6 o'clock. I don't see a reason to change, but if that's something I have to do, I will. I don't want to, but if that's something I have to, I will, because it's less than the time I'm able to have with my child.
You can keep him until 7 p.m. on Sunday, Kenneth. You can even pick him up Thursdays. You can get him every Thursday if you would like. You know, I don't argue with you about getting Carter.
I think the order is, we return to school after weekends.
Yes, when school resumes.
So
If I-
you got a whole nother day there, sir.
let me
What do you
make
mean a whole nother day?
So your order says on
Let me see, Judge. Maybe it's 6. I'm
a
looking.
weekend during regular time. No, it's 6. You talking about on that Sunday?
Sunday, yeah, okay, it is, Judge, yeah.
Yeah.
That's correct, Judge.
And can we clarify the Thursday visitation?
Okay, so let's do this first before we even discuss anything else moving forward. Can Attorney Rogers, could you pull up the final order and go to page 20?
Yes, Judge.
Yes, share your screen. Because I want both of you all, I don't want either of you to violate the court order, right? And court orders can be confusing. So we're going to go over it together so everybody understands what their rights and duties are under the court order.
Thank you.
You're welcome.
And
So
everyone,
can everyone see that?
It's not clearly, no.
Do you have your,
Yeah, I'm getting my order here.
yeah, get your order.
Okay, so scroll down to, it'll be where the beginning, the possession and access order portion starts.
yes, Judge.
Yes, right there. Thank you. So it says for parents who reside 50 miles or less apart, that you all will fall in that. So Mr. Grant, it says on weekends, you shall have the right to possession of the child on weekends throughout the year, beginning at the time the child's school is regularly dismissed on the first, third, and fifth Friday of each month during the regular school term. So if he dismisses at 2, 1, 3, early release, he gets out at noon, whenever, right? You pick him up from school. You got me so far?
Yes, but I have a job. How am I able to do that?
Okay, so we're going to keep going.
Okay.
Give me 1 second. I promise I'll come back to it.
Okay.
Otherwise, if school is not in session at 6 p.m. on the first, third, and fifth Friday of each month, and ending at the time school resumes after the weekend during the regular school term, otherwise, if school is not in session at 6 p.m. on the following Sunday. Now, that says a lot, okay? So essentially, if the child is not in school and the school is not in session at 6 p.m. on the first, third, and fifth, so it's not a regular school dismissal or anything like that, you get him back. I mean, you return him at 6 p.m. on that following Sunday. Does that make sense?
Yes.
Okay. And the following paragraphs talks about a weekend during the school when the school period has been extended. So let's just say, right off the top of my head, Martin Luther King Day normally occurs on a Monday, right?
Right.
So that will be a federal holiday that falls, that falls into the federal holiday. But let's just say it falls on a Friday. Any one of the school years that fall on a Friday, that's specifically talking about a federal, state, local holiday that begins on a Friday or any other day. You got me there so far?
Right. So if it's a Monday, I'll keep him to that on that Monday to 6 p.m.
Yes.
Okay.
Yes, you will. No, I'm sorry. The weekend possession shall end 8 a.m. on that Tuesday. So you will return him back to school if he goes to school the next day.
Okay, and that won't be possible because I work.
Well, I'm trying to slow it down for you. I'm just telling you
Okay.
what the order says, okay?
Okay.
So your Thursday possession schedule, it is on a regular term beginning at the time the child's school is regularly dismissed and ending at the time the child's school resumes on Friday. So you have an overnight on Fridays. Does that part make sense?
Yes.
Now, let me jump you all the way down to general terms and conditions. If you would go all the way down there.
Yes, Judge.
Thank you, counsel. So under this, Mr. Grant, it says either parent may designate any competent adult to pick up and return the child as applicable. A parent or a designated competent adult shall be present when the child is picked up or returned. So to your question about you, or your concern rather, about you having to work and you wouldn't be able to make it at whichever time, that is where you can designate someone, as long as you would consider them a competent adult, to do the exchange for you. Does that make sense?
Yes.
Okay, so do you have any other questions now that we've covered that part of it?
No.
Okay, so Ms. Johnson, in reverse of Mr. Grant, any other time that is not specifically designated for Mr. Grant, you are in possession of the child. Does that make sense?
Yes, Your Honor.
Okay, so moving forward, what I would recommend you all do is really read your court order to get some understanding, because for the most part, the clarification is right there in the order. Some of the legalese can be confusing, but for the most part, it is there. And here's the beauty of it. If you all do not want to follow this to the T, you don't necessarily have to. You can come up with your own agreements. Now, you have to follow it in terms of not violating the other person's rights, right? But if you all, like what you're doing right now, wanting to come to some outside agreements, you're more than welcome to do that. I think it works best for the child when you do it like that anyway.
Okay. Do we need to have it in writing? Like when we work out something, do we have to have it in writing, or we just work it out and follow it that way?
Great question. If you all can work it out without putting it in writing, that's great. If you all feel more comfortable putting it in writing, you can. It doesn't have to be anything formal. It can be in a text message. You all can, if you want to use a co-parenting app, you can put it in there. Wherever, you all feel most comfortable putting it in writing, that's really up to you. I'm not, going to make that an order or anything.
Okay.
Okay, thank you, Mr. Rogers. You can stop sharing the screen.
Good.
So now that we have covered that portion of it, you all have agreed to the McDonald's and Richardson.
Yes.
There is makeup time for the second weekends on those Fridays. So the court is going to order that it's 7 Fridays. Now, mom, if you want to give dad more than 7 Fridays, you can do that. If you want to give dad an extra overnight, if dad can keep Carter a little bit longer, whatever the case may be, football season is coming up. He might want to, stay with his dad a little longer. You just don't know. You know what I mean? But because it is what do you call it? I use football because that's coming up next month, right? So if for any reason there may be something that they want to do together, if you want to do that, you can do that. Dad, if you want to, you and mom can co-parent and you say, hey, I got to work late, whatever the case may be, I have to send him back early. You all should be able to co-parent through that. I should only be here when you literally cannot come to any resolution, okay? All right, and the amount of attorney's fees, the court is going to award dad $2,258.39 in attorney's fees. And Ms. Johnson, you are ordered to pay those attorney's fees directly to is it Seidel? What's the?
Dell Tobachman Family Law PLLC, Your Honor, yes.
Yes, and your attorney can give you the name and the address where you would send it to. I would recommend you do a money order or a cashier's check, so that way you'll also keep a written record for yourself, okay?
Yes, ma'am.
All right, is there anything further we need to take up for the record?
I do
you
request
have-
that we communicate through a parenting app. I asked Mr. Grant that last year, but he's refusing. I think that would be in our best interest to use the co-parenting app.
Okay, so if this were a modification hearing, that would be an easy fix. This is an enforcement. So on an enforcement, I can only enforce what's written, what's there, unless you all come to an agreement. So if he's not agreeing to a co-parenting app, I can't make that order today. If you all do a modification, that's something I'm happy to entertain.
Okay. I'll
Okay,
get on that too.
okay. Attorney Rogers, is there anything further?
Yes, just a few things, Judge. Just to clarify on this ruling, so the first period of time would be on the second weekend of the second Friday of the month, that weekend, coming up in this school year in August, correct?
Let me see. Oh.
Now, Judge, the second is, the
The,
second is the 14th,
the second week
and
is the
school will
14th.
be in. School should be in for most people.
When does school start? Which
Judge,
school?
it started in that preceding week. For
August
them,
12th will be Carter's first day of school.
what day?
August 12th.
Okay, so it'll be in.
Okay, so yes, that the August 14th date would start it.
Okay.
And Mom, when you said that you would do the second weekend, it'll just for record purposes, it'll start when he dismisses from school on August the 14th through that Sunday at 6 p.m. Oh, let me go back.
Thanks, so, Judge.
Let me make sure I'm saying it right, because it's not a school session.
Also said every second Friday.
Yes, so it'll be that second Friday at 6 p.m. and ending that Sunday at 6 p.m.
Meeting at the McDonald's off
Yes.
of Campbell. Okay.
Yes, yes, Mr. Grant, did you understand that?
Yeah, could you repeat that?
Yes, so beginning August the 14th,
Okay,
this is when your makeup time will start. Remember, I said you have 7 of them.
okay,
And if Mom wants to give you more, she can. And what I'm ordering is 7. So beginning on August the 14th, you'll get Carter at the time that I said something different at first, but I'm correcting myself now. So you'll get him beginning at 6 p.m.
okay,
on that Friday, and you'll return back to Mom at the McDonald's Playplace on Sunday at 6 p.m.
okay. And she was 1 and 7, so if we want to change it to 7 for her, we can just do that verbally within each other. Okay,
Yeah, and I want you to. Like, I want to put in the order at 6 p.m. and I want to see you all work through that.
okay.
Okay? All right, Attorney Rogers, was there any other clarification?
Yes, Judge. On the attorney's fees, did you give
We need a
a
date.
due date for those?
Thank you for saying that. I just realized I didn't have a due date for it. Miss Johnson, how much time would you need to pay the attorney's fees?
Am I able to pay it monthly? I don't have $2,000 just hanging out ready to give to somebody.
You can. I like to give an exact date, and if you paid whatever, you could pay, I try to work with you. So if you say you need 4 months, I can make the date 4 months from now, and then you can just pay accordingly. However,
Let's do 6 months. Can we do 6 months?
let's
I
see.
mean, I have a lot on my plate.
So let's see, January the 4th. January 4th.
Directly to the lawyer, right?
Yes,
Okay.
either cashier's check, money order, just however you make your payments, just make sure you do it by cashier's check or money order.
Okay.
All right, and that'll be due January 4th of 2027. Attorney Rogers, you're preparing the order, correct?
Yes, Judge.
All right, how much time do you need to prepare the order?
Just 30 days, Judge. We can have it to you in 30 days.
Let's see.
And then, Judge, would you like that order e-filed to you or emailed?
Please email it to my coordinator.
Yes, Judge.
I don't want it to get lost.
I'll email it to Brittany King.
Yes. So your entry date is August 14th,
Okay.
and that'll be at 9:30 a.m. Now, for any reason that you all, hopefully you don't go beyond the 30 days because we only do one more reset after that. However, if there, for any reason you all are able to get the the order drafted and circulated before the end, just send the signed off order, or it doesn't even have to be signed by you all, but the approval of the order, you would email that to Brittany, and then I'll sign it. I'll remove the date off the computer.
Okay. And then, Judge, one more thing. Is this a Zoom? Just the
Yes,
entry? Okay.
yes,
Thank you, Judge.
you're welcome. All right, Attorney Parker, is there anything further?
Judge, just to clarify, so that when we get it, we're not with each other going, she didn't say that, she said that. The violation is for violation 8, correct?
Correct, that's the
She's
only
found-
violation.
She's found in contempt for that.
Yes.
Okay. Judge, hate to be the one to say this, but is there further sanctions beyond that?
No,
Now the code has found contempt is a bad sanction. When we get 3 of them racked up, you're in big trouble.
Yes.
So that in
Yes.
of itself is bad. Okay.
yes, no further sanctions. And Attorney Parker, thank you for bringing that up. Ms. Johnson, and I'll say it to you too, Mr. Grant, because either of you can be brought before the court on a motion for enforcement. Now, the Texas legislators, starting last year, we can only put you on probation essentially 3 times. That's it. You can only be found in contempt 3 times and be placed on probation. Once you hit that 4th time, the law says I have to place you in jail. I don't like putting people in jail unless I absolutely have to. So I would definitely caution, either of you from violating the court order. Just try to work through it as much as you can.
Yes, Your Honor.
All right. And I just wanted to say something to you all. You all are great parents, and I know Carter, he'll be fine, and I'll tell you why. And I want to applaud you all on the exhibit. I can't remember the exact exhibit number. Mr. Grant was very clear that he did not agree with you moving. I want to say it was December 18th. He was very clear that he didn't agree with you moving out of state. However, you all were able to co-parent through that, and you were asking for him to meet in Shreveport. He said no. And you brought back Marshall and he didn't object to it. So that's good. I don't know if you all you probably were just going through the motions as parents, didn't realize it, but as a judge reading that lets me know that y'all are able to co-parent. So that is good that you all did that. All right, anything further?
Nothing further, Judge.
All right, you all are dismissed. Thank you.
Thank you for your
Thank
time.
you for
Your
your
Honor.
time, Judge.
You're welcome. Have a good one.
Thank you,
Have a
Judge.
good rest of your day.
You're welcome. You too.